Hello, constitutional law students. This is a lecture in which I will discuss a few topics from Module 10 on economic freedom and property rights. I will try at first to explain the Lochner era of the Supreme Court, then the shift in analysis that began in the 1930s, and last the court's current approach to economic liberty, and I'll provide a quick overview of takings law. Let's start with what we mean by the Lochner era. In the last module, I told you about the Supreme Court decision of Lochner versus New York, the case about the baker who was prosecuted for violating New York's maximum hour law. It was that decision that set a precedent of the U.S. Supreme Court for the interpretation of the Due Process Clause with respect to unenumerated liberties. The Lochner case was the first time that the court used substantive due process to recognize and protect an unenumerated civil liberty, the liberty to contract. In Lochner, the court established a test or rubric by which it would judge the validity of economic regulations. Now, the court used slightly different phrasing than we do today, but in essence, it was applying the rational basis standard of review, whether a law is rationally related to a legitimate government interest. Although in Lochner the court found that New York's law failed the test, the rational basis test is a fairly low bar for governments to reach. It affords great deference to the Democratic branch of government in the exercise of its police powers. For a brief time following the Lochner decision, the court struck down many labor regulations. There were a few occasions when it found that a legitimate government interest was being properly served by an economic regulation, such as child labor laws. But most of the economic due process cases of the early 1900s showed a great deal of protection for economic liberty and enforced a strong limitation on a state's use of its police powers to regulate business. In the 1930s, though, we observe a shift in the analysis. Political will developed for the enactment of progressive policies that protected laborers and consumers. That political will trickled up into the Supreme Court. It was still applying the rational basis test, but it nearly always held that the rational basis test was met by the government. The court began upholding legislation that regulated businesses, in particular legislation that was enacted under the authority of the Commerce Clause. The current approach of the Supreme Court is to afford deference to legislatures and uphold laws even when they infringe upon the economic interests of business. However, some scholars are starting to notice that perhaps the tide is turning a bit back toward the Lochner era, and that's just simply due to the current conservative majority that's sitting on the Supreme Court. Related to the notion of economic liberty is the requirement of basic fairness in a government's power to take private property for public use. This due process protection is found in the Fifth Amendment, where it reads, "Nor shall private property be taken for public use without just compensation." The power of a government to take private property for public use is not an enumerated power in the Constitution. It is one of the rare inherent powers of any government. There is a long history of governments commandeering property for the use of the public. The way property owners are protected is through the requirement that they be paid for the property taken. One of the big landmark cases described the Takings Clause this way. It is designed to bar government from forcing some people alone to bear burdens which, in all fairness and justice, should be borne by the public as a whole. In other words, if the public is benefiting from the use of the property, then it's only fair that the public, through the government, should pay for that use. So the analysis of the Takings Clause cases goes like this. Is there a taking of property for public use? And if so, what is just compensation? Let's start with a taking. What is a taking? A taking can be a physical invasion of private property, a physical invasion of private property, however slight. Even just laying a cable in the ground of a person's property constitutes a taking. Another example given in the textbook was a government flying military aircraft low to the ground over a person's property. These are all takings because there's a complete loss of value created by the invasion of at least some small part of a parcel of property. But again, this analysis focuses on the physical occupation of property to any degree. A taking can also occur through regulations that limit the private use of property by its owner. If a regulation goes too far, it will be considered a taking. And whether it has gone too far is determined on a case-by-case basis and through the analysis of three factors: the character of the government action, the economic landscape, and the interference with reasonable investment-backed expectations. Regulatory takings focus not on physical occupation, but instead on economic impact of the government action. So here, with regulatory takings, the extent of the regulation does matter. Governments often regulate the private use of property, but it is when those limitations go too far that a taking has occurred. Next, what is property? And this is really the simple analysis. Property can include personal property, real property, and even intellectual property. The court gives a very broad definition to the term property, and it is not just land. Third, what is public use? Courts give broad discretion to legislatures in the determination of whether to condemn property for public use. Even if a private business is taken by the government for the use or operation of other private businesses, that taking could still be considered a public use depending on the circumstances. And that's an area where we find some controversy. You'll see an example in your textbook when you read Chapter 10. The very last step in the analysis is just compensation. Property owners are entitled to be compensated at the fair market value of the property taken. And that's it. That's an overview of the way takings clause jurisprudence works, and hopefully a fairly clear explanation of how economic liberty is being protected currently and in the past. If you have any questions about other material from Chapter 10 or anything in this lecture, feel free to come see me, email me, or give me a call.